Okay, good day, class. So, in this session, I would like to present to you a video with regards to the relevant provisions of Republic Act 9165, which is the Comprehensive Dangerous Drugs Act of 2002, as amended by RA 10640. Okay, so our video today would be about the crimes that are punishable, or those punishable acts that are commonly um, punished or commonly being violated by individuals, especially with the crimes of selling, possession, and the use of illegal and dangerous drugs. Yan, as mandated by law, of course, there must be provisions in criminal law na merong kaakibat na imprisonment and of course, fines or penalty. So we'll be watching a video with regards to this. Okay, so please stand by as I will present that video. Okay, so this video by um, a certain prosecutor that I will not be naming. Of course, he created this video, which of course is in line with our topics for the second examination, which are, of course, those important provisions of the Comprehensive Dangerous Drugs Act of 2002. Of course, the previous discussions were about the history, characteristics, and of course, the definition of dangerous drugs and other categories of dangerous drugs. So please watch this video. This is almost an hour video. So I hope that you would learn a lot from this video, and hopefully by the time this has been posted, it is already well understood to you those things and provisions in this law that you must be knowledgeable about as future criminologists. So let's play the video.
Good day to everyone. For this video, we are going to discuss the crime of selling, possession, and use of illegal or dangerous drugs. Our discussion will be based on Republic Act 9165 and some relevant jurisprudence. What law penalizes the sale, use, and possession of illegal or dangerous drugs? Take note that Title 5 of the Revised Penal Code on crimes relative to opium and other prohibited drugs, particularly Articles 190 to 194, have been expressly repealed by RA 6425, or the Dangerous Drugs Act of 1972. Now, RA 6425 in turn was expressly repealed by RA 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002. Hence, the governing law at present is RA 9165. Now, considering the repeal of Title 5 of the Revised Penal Code on crimes relative to opium and other prohibited drugs, should the penal provisions in RA 9165 be considered mala in se, or shall they be considered mala prohibita? Answer: the provisions in RA 9165 should be considered generally mala prohibita, meaning to say the degree of participation of the offenders is not considered. All those who perpetrate the prohibited acts are penalized to the same extent. There is no principal or accomplice or accessory to consider. In short, the degree of participation of the offenders does not affect their liability, and the penalty on all of them are the same, whether they are principals or merely accomplices or accessories.
Okay, so let me just pause on that portion. So sa mga hindi nakakaalam ano yung mala prohibita or mala inse. So as per what was mentioned, ang mala prohibita, of course, from the word prohibit, those offenses or acts which are prohibited by law. Yan. Those that are considered illegal, of course, for multiple reasons, of course, public safety, yan. And of course, it is dangerous to someone or to everyone. Yan yung mala prohibita. Hindi siya inherently a sin or hindi siya malalim na pagkakamali. But of course, the government has created measures for it to be limited and prohibited. Ayan. So yan yung mala prohibita. It is not wrong in itself when you compare it to mala in se, which is of course maling-mali talaga, kapatid. It is really wrong in itself. Yan yung translation yan. Mala in se. An act that is wrong in itself. Mala prohibita means an act which is prohibited. Okay? So let's continue on the video.
In addition, Section 98 of Republic Act 9165 specifically provides that notwithstanding any law, rule, or regulation to the contrary, the provisions of the revised penal code as amended shall not apply to the provisions of RA 9165 except in the case of minor offenders. This was the ruling of the Supreme Court in People versus Collado. Also, the principles of graduation of penalties under Article 61 of the revised penal code, penalties consisting of several periods, and computation of penalties under Articles 63 and 64 also of the revised penal code are not applicable with respect to violations under RA 9165. And if I may add, you may have observed that the penalties provided for in RA 9165 do not use the nomenclature of penalties provided for in the revised penal code. What are the punishable acts in Republic Act 9165? We have Section 4 on importation of dangerous drugs and or controlled precursors and essential chemicals. Section 5 on sale, trading, administration, dispensation, delivery, distribution, and transportation of dangerous drugs and or controlled precursors and essential chemicals. Section 6 on maintenance of a den, dive, or resort. Section 8 on manufacture of dangerous drugs and or controlled precursors and essential chemicals. Section 9 on illegal chemical diversion of controlled precursors and essential chemicals. We also have Section 10 on manufacture or delivery of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs and or controlled precursors and essential chemicals. Section 11 on possession of dangerous drugs. Section 12 on possession of equipment, instrument, apparatus, and other paraphernalia for dangerous drugs. Section 13 on possession of dangerous drugs during parties, social gatherings, or meetings. Section 14 on possession of equipment, instrument apparatus, and other paraphernalia for dangerous drugs during parties, social gatherings, or meetings. Then we also have Section 15 on use of dangerous drugs. Section 16 on cultivation or culture of plants classified as dangerous drugs or are sources thereof. Section 17 on maintenance and keeping of original records of transactions on dangerous drugs and or controlled precursors and essential chemicals. Section 18 on unnecessary prescription of dangerous drugs. Section 19 on unlawful prescription of dangerous drugs. Section 27 on the criminal liability of a public officer or employee for misappropriation, misapplication, or failure to account for the confiscated, seized, and/or surrendered dangerous drugs, plant sources of dangerous drugs, controlled precursors and essential chemicals, instruments, paraphernalia, and/or laboratory equipment, including the proceeds or properties obtained from the unlawful act committed. Then, lastly, we have Section 29 on the criminal liability for planting of evidence. Before we discuss the crimes of selling, possession, or use of illegal or dangerous drugs, we must first ascertain ano ba itong illegal or dangerous drugs. The answer to that can be found in Section 3J of Republic Act 9165, which provides dangerous drugs are those listed in the schedules annexed to the 1961 Single Convention on Narcotic Drugs as amended by the 1972 Protocol and in the schedules annexed to the 1971 Single Convention on Psychotropic Substances as enumerated in the attached annex, which is an integral part of Republic Act 9165. For purposes of this discussion, however, we shall only mention the more popular ones because ang dami nila. Methamphetamine hydrochloride, otherwise known as shabu, cannabis or marijuana, and the party drug known as ecstasy. I will no longer mention the scientific name. Methylenodioxymethamphetamine. Ayan, nakuha ko na. Ito lang yung tatlong illegal or dangerous drugs na sikat sa Pilipinas. Although there are other dangerous drugs as listed in Republic Act 9165. Now, after identifying what these dangerous drugs are, we shall now discuss the elements of the crime of illegal sale of dangerous drugs. In order to convict a person charged with the crime of illegal sale of dangerous drugs under Section 5, Article 2 of RA 9165, the prosecution must prove the following elements. First element, the prosecution must prove the identity of the buyer as well as the identity of the seller, the object, and the consideration. And second element, the prosecution must also prove the delivery of the thing sold and the payment therefor, as ruled in the case of People versus Manabat, a fairly recent case. What is important is that the sale transaction of drugs should actually take place and that the object of the transaction is properly presented as evidence in court and is shown to be the same drugs seized from the accused. In order to comply with the said elements I mentioned a while ago, law enforcers usually resort to what is called the buy-bust operation. What then is a buy-bust operation? The case of People versus Ong is instructive. In that case, the Supreme Court explained what a buy-bust operation is, and according to the Supreme Court, a buy-bust operation is a form of entrapment which in recent years has been accepted as a valid means of arresting violators of the dangerous drugs law. It is commonly employed by police officers as an effective way of apprehending offenders in the act of committing a crime. In a buy-bust operation, the idea to commit a crime originates from the offender without anybody inducing or prodding him to commit the offense. Its opposite is instigation or inducement, wherein the police or its agent lures the accused into committing the offense in order to prosecute him. When instigation happens, the accused can raise this as a defense in court because it is deemed contrary to public policy, and when he is able to prove that he was merely instigated by the law enforcers into committing the crime, it will be considered as an absolutory cause which will exonerate him from criminal liability. Now, in the case of People versus Doria, the Supreme Court had occasion to explain the so-called objective test in buy-bust operations. Ano ba itong objective test? The Supreme Court further explained that in order to comply with the objective test, the prosecution must present a complete picture detailing the transaction, the sale transaction, which must start from the initial contact between the poster buyer and the pusher. Then the prosecution must show also that there was an offer to purchase, then the promise or payment of the consideration until the consummation of the sale by the delivery of the illegal drug subject of the sale. The Supreme Court, in that case, emphasized that the manner by which the initial contact was made, the offer to purchase the drug, the payment of the buy-bust money, and the delivery of the illegal drug must be the subject of strict scrutiny by the courts to ensure that law-abiding citizens are not unlawfully induced to commit an offense. In order to determine whether there was a valid entrapment or whether proper procedures were undertaken in effecting the buy-bust operation, it is incumbent upon the courts to make sure that the details of the operation are clearly and adequately laid out through relevant material and competent evidence. For the courts could not merely rely on the presumption of regularity in the performance of official duty by law enforcers. This presumption of regularity should not by itself prevail over the presumption of innocence and the constitutionally protected rights of the individual. It is the duty of the courts to preserve the purity of their own temple from the prostitution of the criminal law through lawless enforcement. Courts should not allow themselves to be used as instruments of abuse and injustice, or else innocent persons are made to suffer the unusually severe penalties for drug offenses. So, dapat stricto talaga ang courts in determining whether there was really a valid buy-bust operation. It must be proven by or through relevant material and competent evidence. The sale transaction must be clearly laid out by the prosecution in order to convince the court trying the case that what happened was a form of entrapment and not just an instigation. Here is an example of a valid buy-bust operation. After weeks of casing and surveillance and the conduct of several test-buy operations, the chief of police in the municipality of Malolos, Bulacan was able to confirm that X was indeed a peddler of shabu in the said municipality. He then called his men for a briefing inside the police station for the purpose of conducting a buy-bust operation against X. The bypass team was composed of the following: Policeman A as the poster buyer, Policeman B as the arresting officer, Policeman C as the searcher, Policeman D as the evidence custodian, and Policeman E as the photographer. Now, in that briefing, the chief of police instructed his police investigator to contact in advance the barangay chairman. He also instructed him to contact a representative from the DOJ and a representative from the media so that their presence could be secured at the time and place of the planned buy-bust operation. The chief also handed over to Policeman A, the one assigned as the poster buyer, a 500 peso bill and instructed him to mark the same with his initials and signature, as it was going to be used as marked money for the purchase of shabu from X. He likewise instructed his police investigator to coordinate with the Philippine Drug Enforcement Agency so that they would be informed of the planned buy-bust operation. After the briefing, the buy-bust team contacted their confidential informant named F and instructed the latter to set up a meeting with X so that the sale transaction could take place. On the day agreed upon, Policeman A, the poster buyer, in civilian clothes, accompanied by the confidential informant, proceeded to the place where X was waiting. The rest of the team followed and stopped at an area where they would not be seen but where they could still observe the transaction from a distance. The confidential informant then introduced Policeman A to X. X then asked Policeman A how much he was going to buy, for which the policeman answered, 500 pesos lang, boss. X then took out a small transparent plastic sachet containing white crystalline substance from his right side pocket and handed it over to Policeman A, who in turn handed over to X the 500 peso bill marked money. After the consummation of the sale transaction, Policeman A then took out his cell phone as if he were to call someone, which was actually the pre-arranged signal that the transaction had taken place. Policeman B, the one assigned as the arresting officer, after seeing the pre-arranged signal, immediately swooped in to apprehend and restrain X, who was at that time caught off guard. The rest of the buy-bust team followed suit and immediately cordoned the area to prevent X from escaping. Policeman B then informed X that he was under arrest for violation of Section 5 of RA 9165 and explained to him his Miranda rights in a dialect which he could understand. Thereafter, Policeman C, the one designated as the searcher, conducted a body search on X for possible possession of dangerous weapons, but he instead found another two pieces of small transparent plastic sachets, each containing white crystalline substance, in his right side pocket, while the 500 peso bill marked money was found inside X's left side pocket. Now, the operation does not stop here. I'm just showing to you what happens in a buy-bust operation. We still have yet to discuss the requirement that after the buy-bust operation, police officers are required to conduct an inventory and photographing of the items seized from the offender. Under the Philippine National Police Drug Enforcement Manual, the conduct of buy-bust operations requires the following. The team must record the time of jump-off in the station's logbook. Alertness and security shall at all times be observed. Actual and timely coordination with the nearest PNP territorial units must be made. Area security and dragnet or pursuit operation must be provided. Use of necessary and reasonable force should be done only in case of suspect's resistance. If buy-bust money is dusted with ultraviolet powder, the buy-bust team must make sure that the suspect gets hold of the same and his palm or palms contaminated with the powder before giving the pre-arranged signal and before proceeding to arrest the suspect. Although for this particular requirement, it is enough that the police officer concerned will mark the buy-bust money with his initials and signature because it is not all the time that they are equipped with ultraviolet powder. Also, in pre-positioning of the team members, the designated arresting elements must clearly and actually observe the negotiation or transaction between the suspect and the poser buyer. They must also arrest the suspect in a defensive manner, anticipating possible resistance with the use of deadly weapons which may be concealed in his body, vehicle, or in a place within arm's reach. After the lawful arrest, they must search the body and the vehicle, if any, of the suspect for other concealed evidence or deadly weapon. This is allowed, no? This is called a valid search incidental to a lawful warrantless arrest. They must also apprise the suspect, this is very important, of his constitutional rights, his Miranda rights, loudly and clearly in a dialect which he could understand after having been secured with handcuffs. They must also take actual inventory of the seized evidence by means of weighing and or physical counting as the case may be. They must also prepare a detailed receipt of the confiscated evidence for issuance to the possessor or suspect thereof. Also, the seizing officer, normally the poser buyer and the evidence custodian, must mark the evidence with their initials and also indicate the date, time, and place the evidence was confiscated or seized. They must also take photographs of the evidence while in the process of taking the inventory, especially during weighing or counting, and if possible under existing conditions, the registered weight of the evidence on the scale must be focused by the camera. Although at present, this is not all the time required because not all police units are equipped with weighing scales. It is enough that the items are counted, adequate, not adequately, but accurately counted. And take note, only the evidence custodians shall secure and preserve the evidence in an evidence bag or in appropriate container and thereafter deliver the same to the PNP Crime Laboratory Group for laboratory examination. Question: should there be a witness or should there be witnesses aside from the policeman who must observe the conduct of the buy-bust operation? The answer is yes. As held in the case of People versus Tumawis, the presence of the witnesses from the DOJ, media, and from public elective office is necessary to protect against the possibility of planting, contamination, or loss of the seized drug. The Supreme Court in that case emphasized that the presence of these witnesses must be secured not only during the inventory, but more importantly at the time of the warrantless arrest, because it is at this point in which the presence of the three witnesses is most needed, as it is their presence at the time of seizure and confiscation that would belie any doubt as to the source, identity, and integrity of the seized drug. Now, if the buy-bust operation is legitimately conducted, then the presence of these insulating witnesses would also controvert the usual defense of frame up, as the witnesses would now be able to testify that the buy-bust operation and inventory of the seized drugs were done in their presence in accordance with Section 21 of Republic Act 9165. Ang nangyayari kasi is yung mga witnesses from the DOJ, media, and from public elective office, dumadating na lang at the time of the inventory. Minsan pa nga, it would take 30 minutes or an hour before these witnesses would arrive. And it would now defeat the purpose of Section 21 because Section 21 requires that after the buy-bust operation, an inventory and photographing of the item seized must immediately be conducted. Now, if these witnesses are not yet around at the time of the warrantless arrest, then that would defeat the purpose of the law. Kaya nga, sinasabi dito sa case ng People versus Tumawis, it is at that point during the warrantless arrest in which the presence of these witnesses is most needed. Because their presence would belie any doubt as to the source, identity, and integrity of the seized drug. Why? Because they would now be able to witness if indeed a buy-bust operation had really taken place. The Supreme Court in that same case made the observation that the practice of police operatives of not bringing to the intended place of arrest the three witnesses when they could easily do so and calling them in to the place of inventory to witness the inventory and photographing of the drugs only after the buy-bust operation has already been finished does not achieve the purpose of the law in having these witnesses prevent or insulate against the planting of drugs. Klarong-klaro. This is the evil sought to be avoided by this requirement. To restate, the presence of the three witnesses at the time of seizure and confiscation of the drugs must be secured and complied with at the time of the warrantless arrest, such that they are required to be at or near the intended place of the arrest so that they can be ready to witness the inventory and photographing of the seized and confiscated drugs immediately after seizure and confiscation. Should there be an inventory of the seized items immediately after the buy-bust operation? The answer is yes. The duty of the police officers or the buy-bust team does not stop with the buy-bust operation. Section 21, Article 2 of RA 9165 lays down the procedure that police operatives must follow to maintain the integrity of the confiscated drugs. The said provision requires that, number one, the seized items be inventoried and photographed immediately after seizure or confiscation. At this point, take note of the underscored portion, immediately after. And second, the physical inventory and photographing must be done in the presence of the accused or his or her representative or counsel, an elected public official, a representative from the media, and a representative from the Department of Justice, all of whom shall be required to sign the copies of the inventory and be given a copy thereof, and the seized drugs must be turned over to the PNP Crime Laboratory within 24 hours from confiscation or examination. Now, you might ask, Fiscal, paano kung ayaw pumirma ng offender or ng accused? Of course, we cannot force the accused to sign if he does not want to sign. But the police officers or the buy-bust team must explain the refusal to sign or state the reason why the accused refuses to sign in writing through the execution of an affidavit, which is one of the documents that they will submit during the inquest proceeding. The phrase immediately after seizure and confiscation in Section 21 means that the physical inventory and photographing of the drugs were intended by the law to be made immediately after or at the place of apprehension. It is only when the same is not practicable that the implementing rules and regulations of RA 9165 allow the inventory and photographing to be done as soon as the BIBAS team reaches the nearest police station or the nearest office of the apprehending officer or team. To reiterate, Section 21 requires that the copies of the inventory should be signed by all of the following persons: the accused or his or her representative or counsel, an elected public official, a representative from the media, and a representative from the DOJ. This was emphasized in the case of People versus Manabat. Question: will non-compliance with Section 21 render the seizure of the items void? Not necessarily. Under varied field conditions, strict compliance with the requirements of Section 21 of RA 9165 may not always be possible, and the failure of the apprehending team to strictly comply with the procedure laid out in Section 21 does not ipso facto render the seizure and custody of the items void and invalid. Take note, however, that this is with the caveat that the prosecution still needs to satisfactorily prove that, letter A, there is justifiable ground for non-compliance, and letter B, the prosecution must prove that the integrity and evidentiary value of the seized items are properly preserved, because it is their positive duty to explain the reasons behind the procedural lapses. Now, without any justifiable explanation, which must be proven as a fact, the evidence of the corpus delicti becomes unreliable, and the acquittal of the accused should follow on the ground that his guilt has not been shown beyond reasonable doubt. This was ruled in the case of People versus Claudel. Another question: is there an exception to the rule on the mandatory presence of the three witnesses who are required to be present not only during the inventory but also at the time of the warrantless arrest? In the case of People versus Romy Lim, the Supreme Court stressed that the prosecution has the burden of, number one, proving its compliance with Section 21. Now, in case of non-compliance, the prosecution must provide a sufficient explanation. Now, how did the Supreme Court emphasize this rule in the said case of People versus Lim? According to the Supreme Court, the BIBAS team must allege and prove that the presence of the three witnesses to the physical inventory and photograph of the illegal drug seized was not obtained due to reasons such as their attendance was impossible because the place of arrest was a remote area, or their safety during the inventory and photograph of the seized drugs was threatened by an immediate retaliatory action of the accused or any person or persons acting for and in his or her behalf, or the elected official himself is involved in the punishable act sought to be apprehended, or earnest efforts to secure the presence of a DOJ or media representative and an elected public official within the period required under Article 125 of the Revised Penal Code has proven futile through no fault of the arresting officers who face the threat of being charged with arbitrary detention, or time constraints and urgency of the anti-drug operations, which often rely on tips of confidential assets, prevented the law enforcers from obtaining the presence of the required witnesses even before the offenders could escape. These are the allowable reasons to excuse the bypass team from compliance with the requirement that the three witnesses must be present not only during the inventory but more importantly at the time of the warrantless arrest. At this juncture, allow me to make a clarification on the application and interpretation of the three-witness rule as provided for in Section 21 of Republic Act 9165. Kasi ang nangyayari ngayon is that yung mga police operatives natin, medyo confused sila kung kailangan ba talagang tatlong witnesses ang nagwi-witness during the inventory or pwede bang dalawang witness na lang out of the three. Take note that prior to the effectivity of RA 10640 on August 7, 2014, which amended Section 21 of RA 9165, the applicable rule then was the original provision of Section 21 and its implementing rules and regulations, which required the presence of the three witnesses to the inventory. But with the enactment of Republic Act 10640, which law became effective on August 7, 2014, the rule now only requires two witnesses to be present during the conduct of the physical inventory and taking of photograph of the seized items, namely, an elected public official and either a representative from the DOJ or the media. So, what does this mean? Dapat during the inventory, present always yung elected public official together with either a representative from the DOJ or from the media. Hindi pwedeng ang nag-witness ng inventory is from the DOJ and from the media lang. As clearly underscored in Republic Act 10640, the amendatory law or the law that amended Section 21, allowed yung dalawang witness lang, but the witness that must be present during the inventory should be an elected public official and either a representative from the DOJ or the media. Always dapat nandun yung elected public official. Hence, for crimes involving the sale or possession of illegal drugs that were committed prior to August 7, 2014, which is the date of effectivity of RA 10640, the three-witness rule applies. And from August 7, 2014 onwards, the two-witness rule applies. What about this statement of compliance or explanation as to non-compliance of the mandatory requirements of Section 21? In the same case of People versus Slim, the Supreme Court made the following pronouncement. The Supreme Court said, in order to weed out early on from the court's already congested docket any orchestrated or poorly built-up drug-related cases, the following should henceforth be enforced as a mandatory policy. Number one, in the sworn statements or affidavits, the apprehending or seizing officers must state their compliance with the requirements of Section 21. That's what I mentioned in the previous slides. Second, in case of non-observance of Section 21, the apprehending or seizing officers must state the justification or explanation therefor, as well as the steps they have taken in order to preserve the integrity and evidentiary value of the seized or confiscated items. Third, if there is no justification or explanation expressly declared in the sworn statements or affidavits of the seizing officers, then the investigating fiscal or the inquest prosecutor should not immediately file the case before the court, because the rule here is that since this is an inquest proceeding, an inquest prosecutor is given only a maximum of 36 hours from the time of the arrest within which to file the information. But since in this situation, the seizing officers did not offer any justification or explanation, then the Supreme Court mandates the inquest prosecutor to not immediately file the case before the court, and instead he or she must refer the case for further preliminary investigation in order to determine the existence or non-existence of probable cause. Now, if the inquest prosecutor files the case despite the absence of such justification or explanation, then the court where the information is filed may exercise its discretion to either refuse to issue a commitment order or warrant of arrest, as the case may be, or dismiss the case outright for lack of probable cause in accordance with Section 5, Rule 112 of the Rules of Court. Take note here that the application of the above requirements is prospective. What do I mean by this? For crimes involving the sale or possession of illegal drugs that were committed prior to the promulgation of People v. Slim on September 4, 2018, the inquest prosecutor can immediately file the case in court even if there is no statement of compliance or explanation as to non-compliance. My discussion of Section 21 in the previous slides is just actually part of what I will be discussing in this slide, which is the chain of custody rule. Now, ano ba itong chain of custody rule? In the case of People versus Diputado, as well as in Section 1B, Dangerous Drugs Board Resolution or Regulation Number 1, Series of 2002, chain of custody is the duly recorded authorized movements and custody of seized drugs or controlled chemicals or plant sources of dangerous drugs or laboratory equipment of each stage from the time of seizure or confiscation to receipt in the forensic laboratory to safekeeping and their presentation in court for identification and destruction. This record of movements and custody shall include the identity and signature of the person who held temporary custody of the seized item, the date and time when the transfer of custody was made in the course of the item's safekeeping and use in court as evidence, and its final disposition. Let me explain further. There are actually 4 links in the chain of custody that must be proved. This was emphasized in the case of People versus Hementiza. The first link in the chain is the seizure and then the marking of the dangerous drug recovered from the accused by the poster buyer or by the searcher. The second link in the chain of custody is the turnover of the dangerous drug purchased by the poster buyer or seized by the searcher to whom? To the evidence custodian. Now, the third link in that chain is the turnover by the evidence custodian of the dangerous drug, this time to the forensic chemist for laboratory examination or chemical analysis. And the last link in the chain is the turnover and submission of the marked dangerous drug from the forensic chemist who conducted a laboratory examination thereof to determine the presence of dangerous drugs, this time to the court when the same is presented as evidence in the criminal case. So take note of these four links in the chain of custody. Now, to further explain this chain of custody rule, the chain of custody would include testimony about every link in the chain, from the moment the item was seized to the time it is offered in evidence, in such a way that every person who touched the exhibit or who touched the drug item, from the poster buyer to the evidence custodian, from the evidence custodian to the forensic chemist, and from the forensic chemist to the court, should describe how and from whom it was received, where it was, and what happened to it while in the witness's possession, the condition in which it was received, and the condition in which it was delivered to the next link in the chain. These witnesses would then describe the precautions taken to ensure that there had been no change in the condition of the item and no opportunity for someone not in the chain to have possession of the same. So this was emphasized, no, sufficiently and clearly in the case of People versus Makud. The requirement as to marking means that the appending officer or the poster buyer must place his or her initials and signature on the seized item. The marking of the evidence serves to separate the marked evidence from all other similar or related evidence from the time they are seized from the accused until they are disposed of at the end of the criminal proceedings, thus preventing switching, planting, or contamination of the evidence. Importante itong marking po dahil it is only by marking that the police officers or every person who touched the drug item in the chain of custody will be able to identify the same in open court. They cannot be expected to identify the item if that item has no marking, which will indicate that they indeed got into possession of the same because they had placed their initials and signature on the seized item. And with marking, as emphasized in the case of People versus Patricia, it will prevent switching, planting, or substitution of the evidence. Also take note that marking after seizure is the starting point in the custodial link. It is vital that the seized contraband be immediately marked because succeeding handlers of the specimens will use the markings as reference, as what I mentioned a while ago. Marking, though, should be done in the presence of the apprehended violator immediately upon confiscation to truly ensure that they are the same items which enter the chain of custody. Also, it is of paramount necessity that the forensic chemist testifies on the details pertaining to the handling and analysis of the dangerous drug submitted for examination. For example, when and from whom the dangerous drug was received, what identifying labels or other things accompanied it, the description of the specimen, and the container it was in. Furthermore, the forensic chemist who conducted the laboratory examination must also identify the name and method of analysis used in determining the chemical composition of the subject specimen. This was ruled in the case of People versus Umamos. Now, let us go to Section 11 of RA 9165. And the question is that pertains to Section 11, possession of illegal drugs, is to ask what are the elements of the crime of possession of illegal or dangerous drugs. Illegal possession of dangerous drugs under Section 11, Article 2 of RA 9165 has the following elements. Number 1, the accused is in possession of an item or object which is identified to be a prohibited or regulated drug. Second element, his possession thereof is not authorized by law. And third element, the accused freely and consciously possessed the drug. Take note that the crime of illegal possession of dangerous drugs is malum prohibitum, and as such, criminal intent is not an essential element. However, the prosecution must prove that the accused at the very least had the intent to possess, or animus possidendi. Now, possession under the law includes not only actual possession but also constructive possession. Actual possession exists when the drug is in the immediate physical possession or control of the accused, like when the sachet of shabu is found in the pocket of the accused. That is actual possession or immediate physical possession. Constructive possession, on the other hand, exists when the drug is under the dominion and control of the accused, or when he has the right to exercise dominion and control over the place where it is found. For example, if the sachet of shabu is found inside the room of the offender or room of the accused. However, exclusive possession or exclusive control is not necessary. The accused cannot avoid conviction even if his right to exercise control and dominion over the place where the contraband is located is shared with another. For example, the accused shares a room with another person. So that means the accused does not have exclusive possession or control over that room. But the sachet of shabu was found either under his bed or under his pillow or inside his closet, such closet being inside the room. That will not negate his conviction for illegal possession of dangerous drugs just because he shares the room with another. Because assuming that the prosecution is able to prove, and assuming that the testimony of the police officer who was able to recover that sachet of shabu inside the closet of the accused is credible, then there is no rhyme or reason why the accused should not be convicted. Now, in possession of illicit drugs cases, also take note that ownership of the drug is inconsequential. Mere possession of the illicit drug is malum prohibitum, and the burden of proof is upon the accused to prove that they or he has a permit or clearance to possess the prohibited drug. This was ruled in the case of People versus Quijano. Now, on to our last topic for this video. Question: is there criminal liability for one who is caught using illegal or dangerous drugs? The answer is found in Section 15, Article 2 of RA 9165 on use of dangerous drugs, which provides: a person apprehended or arrested who is found to be positive for use of any dangerous drug after a confirmatory test shall be imposed a penalty or a minimum of 6 months rehabilitation in a government center for the first offense, subject to the provisions of Article 8 of this Act. if apprehended using any dangerous drug for the second time, he or she shall suffer the penalty of imprisonment ranging from 6 years and 1 day to 12 years and a fine ranging from 50,000 to 200,000 pesos, provided that this section shall not be applicable where the person tested is also found to have in his or her possession such quantity of any dangerous drug provided for under Section 11 of this Act, in which case the provisions stated therein shall apply. Breaking down this article, when the offender is found using any dangerous drug for the first time, he will be subjected to 6 months rehabilitation in a government center, subject to the provisions of Article 8 of RA 9165 on voluntary and involuntary submission of a drug dependent for confinement, treatment, and rehabilitation. That is for the first offense. Like what I said, if the offender is found or caught using any dangerous drug for the first time. Now, if the offender is found using any dangerous drug for the second time, then he will be liable for imprisonment ranging from 6 years and 1 day to 12 years and a fine ranging from 50,000 to 200,000 pesos. It is also clear that Section 15 does not apply when a person who is found positive for use of dangerous drugs or who is caught using dangerous drugs is also found to be in possession of the same. What do I mean by this? This means that there will only be one charge for violation of Section 11. There will be no separate charge for violation of Section 15 because here the illegal possession of dangerous drugs absorbs the use of dangerous drugs. For example, X was caught in possession of shabu. After the inventory and marking of the shabu ceased from his possession, X was brought to the police crime laboratory to have his urine sample taken for a confirmatory test or for examination. Now, the result of the urine test showed that he was positive for use of dangerous drugs. Question: will he also be charged for violation of Section 15 aside from being charged with violation of Section 11? The answer is not anymore because the use of dangerous drugs is absorbed or will be absorbed in the crime of possession of dangerous drugs. There will only be one charge of violation of Section 11.